Hello everyone, my name is Jason Wright, and today I'm going to be talking about a darker time in the history of laws passed by Congress that affected the United States military and has been found discriminatory underneath the due process and freedom of speech clauses of the United States Constitution. This policy that I'm speaking about is the 1993 Don't Ask, Don't Tell policy that was passed by Congress during the Clinton administration. Simply, this put into perspective that a member of the service could not be asked nor be required to tell whether they were lesbian, gay, or bisexual to serve in the military. They could not be asked during recruitment or time of service. The downfall of this was that service members who were found to be homosexual or suspected could be court-martialed, investigated, and end up discharged from the military, including a dishonorable discharge. This issue directly related to hundreds of thousands of people losing their jobs, their careers, and their future. Cases similar to this would be the Frontier v. Richardson case, which proved that denial of benefits to a male spouse was unconstitutional, and the Goodridge versus Commissioner of Public Health, which was the first case in Massachusetts and in the United States, stating that marriage between one man and one woman was unconstitutional and allowed same-sex marriage to begin in the state of Massachusetts, as well as the granting of benefits to same-sex spouses. Now, the first people to actually challenge this case, which is actually the case name, is the Log Cabin Republicans, case being Log Cabin Republicans v. United States. And they are simply a conservative group made up of LGBT members and LGBT supportive members who are simply looking to continue conservative beliefs without the denial of rights and benefits to members of the community that do not fit into the stereotypical conservative style of thinking and way of life. Now, Lambda Legal did put out a phenomenal timeline. I'm not going to go over all of it. I'm going to focus on some of the main issues with the case so that a greater understanding can be made. Of course, in 1993, Congress initially passed the Don't Ask, Don't Tell, also known as DADT law. And in 2004, the Log Cabin Republicans filed a charge to challenge this policy. Now, the Log Cabin Republicans and the people who filed did include current and previous service members who were either under investigation, living in hiding, or had been discharged due to this law. Now, we don't see much history between 2004 and 2010 due to the courts having to go through and investigate and determine whether or not this was in fact unconstitutional. And the ruling from the U.S. District Court came out on September 9th, 2010 that did rule that DADT was unconstitutional. Now, from September 9th all the way until, December 22nd, 2010, there was a lot of issues pertaining to whether or not Don't Ask, Don't Tell could be enforced, whether or not it couldn't be. There, of course, were challenges from the United States government. One of the main things was that Lambda Legal did file charges against the U.S. government trying to prove that this was unconstitutional on behalf of the Log Cabin Republicans, and there was injunctions put in place barring the government from actually enforcing this policy. Key date with this is December 22nd, 2010, which is the date in which President Obama signed the Don't Ask, Don't Tell Repeal Act. And that basically simply was to repeal it and also state that 60 days after he and others certify repeal can be implemented. Of course, there was more appeals through Lambda Legal and, of course, the Log Cabin Republicans helping to ensure that this could not be enforced. And on July 6, 2011, the Ninth Circuit Court of Appeals lifted its stay on the injunction, and of course the government was once again prevented from enforcing Don't Ask, Don't Tell. Now, a major issue with this case was that on July 15, 2011, there was a change to the injunction barring the U.S. military from enforcing this. And it changed to where members of the military that were currently serving under investigation and their discharge proceedings were not permitted to be discharged underneath this law. But underneath the current injunction on July 15th was that if you were attempting to join the service, you could not be openly lesbian, gay, or bisexual. That is where there was an issue with this. But on July 22nd, only about a week later, President Obama, the Honorable Defense Secretary Panetta, and the Chairman Joint Chief of Staff, the Honorable Admiral Mullen, certified the repeal of Don't Ask, Don't Tell, which finally lifted the ban on lesbian, gay, and bisexual service members from serving openly. The date that this was officially put into effect was on September 20th, 2011. And on that same day, the Ninth Circuit Court orders that its July 15th order remain in effect until the resolution of this case. And finally, September 29th, 2011, the Ninth Circuit Court of Appeals vacates earlier district court ruling declaring Don't Ask, Don't Tell unconstitutional. The issue with this case was that the U.S. government is very difficult to challenge, and of course, anyone attempting to challenge the government must have a massive amount of evidence proving that something is unconstitutional. Of course, the denial of an entire group of citizens from being able to serve their country as a volunteer is a direct violation of their freedom of speech rights given within the Constitution, as well as the due process laws, which actually was forcing them away from their jobs and their entire life goals, and possibly ruining their futures due to a ban that was incredibly discriminatory and unnecessary. Luckily, we don't have this issue now, and as of right now, we are attempting to fight for the rights for trans service members to be able to finally serve openly. But the log cabin Republicans made history by removing the discriminatory laws of Don't Ask, Don't Tell in the United States military.